This is Speaking Freely with the ACLU of Pennsylvania. I'm Andy Hoover, your host and Director of Communications at the ACLU of PA. Both the U.S. and Pennsylvania constitutions guarantee the right to an attorney for someone facing criminal charges, regardless of a person's ability to pay. You've no doubt heard the phrase, you have a right to an attorney. If you cannot afford an attorney will be appointed to you on some cop show. That's not fiction. It's how things work or are supposed to work. But for decades, Pennsylvania has been woefully inadequate in ensuring that people living in poverty receive effective representation. The people working in the Commonwealth's public defender offices are hardworking lawyers, but the state doesn't provide them with the financial support and oversight they need. Pennsylvania consistently is near the bottom in per capita funding for public defender offices, and until a year ago provided zero state funds for public defenders. Those offices were funded solely by the counties. So in June, the ACLU of Pennsylvania, with volunteer attorneys from several law firms, sued the governor and the leaders of the General Assembly because the executive and legislative branches have failed their constitutional duties. In this episode, we hear from Veronica Miller, Senior Policy Counsel for Criminal Legal Reform, and Ari Shapell, Fellowship Attorney, both with the ACLU of Pennsylvania. Veronica and Ari are co-counsel in the case Warren v. Commonwealth. In our conversation, they explain how Pennsylvania's indigent defense system has failed and what we hope to achieve with this litigation. This conversation was recorded on November 20th. Well, Veronica, Ari, thank you both for joining me. Really appreciate the time to talk about this monumental lawsuit that we have filed back in June. It's been a long time coming, and that's a thing you hear quite a few people saying, that Pennsylvania's public defender system has needed to be shaken up and revamped and reformed for a while. So I appreciate the fact that you can both sit down and chat a little bit about it. Veronica, let's start with you. Explain how Pennsylvania's public defender system is structured and why that made this lawsuit necessary.
Sure. So Pennsylvania has their Public Defender Act, and that was a piece of legislation done back in 1968 as a result of the Gideon v. Wainwright decision. And so with that piece of legislation, the state delegated all of the responsibility for indigent defense, so public defenders' offices, to the counties. They did specifically exclude Philadelphia from that because Philadelphia had its own association of defenders that is funded through the city of Philadelphia. But so minus the county of Philadelphia, the other remaining counties are solely responsible for funding, staffing, directing the public defender's office. The state provides pretty much zero oversight and funding until fairly recently, which we can talk about later. But so it really put the burden and the onerous on counties to develop their systems, which has really resulted in a very piecemeal sort of justice by geography system.
And so to file this lawsuit, Ari, I know that our team did a lot of research in the lead up to filing. You talked with people in jails, you talked with public defenders. There were probably other stakeholders you engaged as well. I know there were some particularly shocking ways in which the lack of state support for public defenders leads to inadequate representation for poor defendants. What did you learn from those conversations that you had with stakeholders?
Well, we learned a lot over the last 2 years that we spent investigating the issue prior to filing our lawsuit. So I think the first thing that drew us to the issue was hearing the plight of indigent people across the state who are being harmed by the indigent defense system. We drove around to county jails throughout the Commonwealth, and we heard story after story of people who felt they were being denied justice in their case because their PDs, public defenders, didn't have the resources or the time to dedicate to their cases. I mean, we saw these issues show up in a whole bunch of different ways. In the most sort of egregious way, we saw indigent people being entirely denied counsel in Northampton County, which is north of Philadelphia. There was one instance where we observed a person show up for a plea hearing on low-level summary offenses, so driving an unregistered car without proof of insurance. And he had spent 3 weeks in jail, in the county jail, on pre-trial detention, awaiting the resolution of these very minor charges, never having been assigned a public defender or appointed any sort of counsel. He had proof that he hadn't been driving without insurance, but he couldn't access his insurance cards because he was incarcerated and indigent. And so he showed up to this hearing and tried to plead guilty just so he could be released from jail. But he wouldn't admit guilt to the judge, and so the judge refused to take the plea, and he got sent back to jail for an additional 2 months before an attorney was appointed for him, and a bail modification was filed to get him out. So, that is sort of an example of entirely missing or entirely sort of the absence of justice in these instances because counties aren't providing for public defenders or appointed attorneys. And then on the flip side, we've also seen that even when indigent people have public defenders or appointed counsel, their attorneys are often so overwhelmed with their massive caseloads that they don't have the time to take all the steps necessary to ensure that their clients get a just outcome in their cases. And so, in addition to talking to people who have been in the justice system, we also talk to a lot of public defenders and appointed attorneys across the state. And they consistently told us that they were underwater and that they were struggling with untenably high caseloads. That's borne out by a study that was done by Paul Heaton, an academic at the Quattrone Center at Penn, who found that the vast majority, I think it was 64 of 67 counties, had caseloads for public defenders that exceeded national standards. And so these public defenders, well, it's really our state government was putting these public defenders, who we know to be broadly hardworking and passionate, dedicated advocates, in this really impossible position because they don't have the time and the resources that they need and want to devote adequate attention to individual cases, and their clients suffer for it. So some of the issues that these attorneys brought up and that were borne out in the investigations we did into individual cases, particularly with the named petitioners whose stories are in the lawsuit that we filed. But we found that public defenders weren't being appointed until the preliminary hearing, which is a hearing that happens typically at least 2 weeks after a person is arrested. So there's a long stretch of time where someone can be sitting in jail on bail that they can't afford without any sort of counsel. And even after they're appointed a public defender, their public defender may not have the time to speak to them in between hearings and keep them apprised of what's going on in their case, or speak with them about case strategy and get them involved in the case. And we heard from a lot of our clients that are named in the case that they made numerous attempts to reach out to their attorneys through phone calls or letters or the jail communication messaging system, and just didn't get any sort of response. And we recognize that that's the result of these attorneys just having way too many cases to be able to dedicate the time of going down to the jail, waiting to be brought to their client, and having those really important meetings with their client. Another issue is that there wasn't any significant investigation happening in most cases. So we did some right to know requests and looked at staffing at public defenders' offices and found that more than half had no dedicated investigators on staff. And other offices only had a couple of investigators for thousands of cases. So in most instances, either the public defender or appointed attorney was forced to do the investigation themselves, which takes them away from other work that they need to be doing, or just no investigation was being done and people were pleading guilty without anyone talking to a witness or investigating an alibi or any of those sort of things that could impact the resolution of a person's case. And there's a whole bunch of other issues. The other one I'll talk about is the lack of advocacy. Public defenders just don't have the time advocate for their clients in as much as they'd like to. Very few cases in Pennsylvania go to trial, and even at hearings before trial, like preliminary hearings, clients will often waive their right to a preliminary hearing on advice of counsel. And so oftentimes there can be just very little advocacy going on behalf of a client by their public defender. And then the last thing I'll mention is that, in our research, it's not just talking to indigent defendants and talking to public defenders. We also reviewed these long reports that have been published by the General Assembly, by Pennsylvania Supreme Court, and other Commonwealth entities that have recognized that the Commonwealth was not providing for the constitutional right to counsel. Going back to 2003, the Supreme Court, the committee released a report saying that the Commonwealth is generally not fulfilling its obligation to provide adequate independent defense counsel to indigent persons, and that was the result of a lack of state funding. And so, those sorts of reports have been really powerful for us to see that this has been a known issue, and that the Commonwealth has been sort of willfully ignorant of its responsibilities to its citizens and to indigent criminal defendants.
I'm glad you mentioned all those issues and the preparation that's necessary for a case, because that that the legal work is obviously so much more than what happens in a courtroom. It's all the prep work and all the investigating that you talked about, and the research and preparation. Veronica, were you about to add to that? It looked like maybe you're going to say something.
Yeah, I did. I just, the reports that Ari mentioned, really highlight the reason why we specifically needed to sue the Commonwealth and all the other named respondents in the case, because ultimately they have the responsibility, but also the power to make the changes necessary that would address so many of these issues that Ari just, explained, that we had heard countlessly from many different people.
We're going to talk about the legislature here in a moment. Always fodder for interesting conversation is the Pennsylvania General Assembly. But before we get there, Veronica, I want to ask you about your experience being a public defender. You were a PD in Dauphin County. Tell us a little bit about that experience. I would imagine what was found in this research may not surprise you. What's a typical day like for a public defender?
Yeah, what I think is most innocuous about the problem in Pennsylvania is that you have a lot of dedicated attorneys working day in, day out, but not being able to really change their status quo. You are so close to the issue that it is really difficult to kind of step back and realize that you, unfortunately, are part of a system that is not bringing about the kind of justice that you wanted to as a public defender, as an attorney. But so what can I say about my time is that I found it extremely valuable. It is a place where you learn so much, and you also build a lot of good relationships with the other attorneys who you're working with, because you're sort of, as we would colloquially say, in the trenches together. There's a lot of hard-won fights in the office. But so, a typical day, I mean, it sort of just runs the gamut. But you can imagine that if it's a court day, you've got a stack of cases and you're trying desperately to get a hold of clients, because unfortunately your clients may or may not have a good telephone number. And so you're waiting and hoping that they show up to court because you're desperately needing to go over some discovery that you recently got, or you needed to go over a plea deal and they're going to potentially plea that day in court and you haven't yet talked to them. And those are just things that attorneys have to unfortunately take for granted or just kind of go with, because you don't have enough time to go and track down clients or meet with clients the day before. Because guess what? I was in the prison talking with clients who had revocation hearings, or I was at an MDJ's office for the better part of the day because I had preliminary hearings. And so every single day you wake up kind of having to assess where which thing is going to have to sort of fall through the cracks because there's clearly just not enough hours in the day to accomplish everything that I need to do on top of maybe preparing for a motion because I have a case that I filed a suppression in, or I had a trial and guess what? Now we're filing post-sentence motions and now we're going to do an appeal. And as a public defender, most of that falls on the individual attorneys. There isn't a large staff of appellate attorneys, or sometimes you do have paralegals who can help assist with like the filings of motions, but for the most part everything that you're going to be doing falls on that individual attorney. And like that doesn't even start to include like problem solving courts and drug court, or various other specific projects where you are now being pulled because maybe you're the most senior attorney now, and now you're handling the felony one, aggravated assaults, or you're now on sex case rotation and you have to go and talk to that client who has the preliminary hearing tomorrow. And there's just an unbelievable amount of things that you are having to accomplish. But more than that, you are constantly aware of the clients who you are not able to serve, who are waiting for you to come and talk to them while they are detained in jail, or the client who thankfully maybe is on the street, but you haven't been able to get a hold of them just because you literally don't have the time. And so, but because they're at liberty, you're thankful that maybe you can continue their case. And so there is just a lot of push and pull of feelings of not doing enough, wanting to do more, but just literally not having the resource of time and the ability to do that. I have to say, thankfully, in that office, like we really prioritized trials and we did do a lot of trials. And so that level of advocacy was there. But again, you get used to only meeting clients the day of the preliminary hearing, where we know best practice is to meet with them beforehand to at least establish whether or not there were witnesses to call, and whether or not you need to send an investigator because there's the potential that somebody needs to be talked to and you're going to miss them or lose them if you don't do it right away. You don't get the opportunity to build good relationships with your clients to be able to better advocate for them, say at like bail hearings. And it begins to weigh on you when you know that you want to do more, but you really just can't. But I think probably the reason it gets so taxing is because you are so much to the clients. You are not just an attorney, but you are often a social worker because you're calling case management to try to get them back for their appointment that they missed, or trying to help them get back on medication management because that's so integral for them to not come back into the system. And then also, arguing with opposing counsel, your fellow attorneys on the other side about what is fair and just. And it does get very exhausting. There is a lot of emotional toll that happens in a public defender's office. And, waking up in the middle of the night thinking, gosh, I should have said this at trial, or I wish I would have done that. And these are cases that already happened. I can't go back in time and redo them. And just knowing that these are people's lives on the line. And it was really stressful, really rewarding when I could put all of my time and effort into a client's case and like get acquittals. Like that was amazing. Like there's nothing like that experience. But then, you often think back about, some of the other clients that you wish you could have just always done a little bit more for.
Well, both of you have effectively described the problem. Let's talk a little bit about the lawsuit. So, Ari, explain the legal claims here and what we're asking the court to do.
What we're asking of the court here is pretty simple. We're asking the court to recognize that there are a set of well-established constitutional rights that the Commonwealth is ignoring and violating, and that is causing harm to our clients. So there are sort of a panoply of constitutional rights that have been hard fought to protect indigent criminal defendants. The Sixth Amendment in the United States Constitution, it carries the right to counsel in criminal cases, and that and other constitutional rights that we're asking the court to recognize in this case were hard fought by indigent criminal defendants and by advocates. The Sixth Amendment right to counsel is something that Veronica mentioned earlier. Gideon v. Wainwright was when the court first recognized that right to counsel, and that was won by a indigent man in Florida who was prosecuted without counsel, and while in jail studied the law, wrote a writ of certiorari to the Supreme Court, and the court decided to hear his case and determined that the Sixth Amendment carried this right to counsel in felony cases. And so, we are sort of riding on the backs of these really brave petitioners and advocates that have established the right to counsel under the Sixth Amendment. There's also a right to counsel under the Pennsylvania Constitution. And we're also claiming that there are other important rights here, like equal protection and due process, that protect indigent defendants' rights to have an attorney on their initial appeal of their criminal case, and more generally, a right to equal protection such that the Commonwealth of Pennsylvania can't set up this patchwork system of public defense that Veronica mentioned, in which the quality of your representation is determined by which of these counties you commit your crime in. So there's these set of constitutional rights. We believe they're clearly being violated by the Commonwealth, which has abdicated its responsibility to protect these rights, and we're asking the court to recognize that.
And if the court does that, they're basically ruling that the system as it currently functions is unconstitutional, but they don't have the power to implement something new, which leads to the General Assembly and the governor. So, Veronica, another part of your bio is you worked in the legislature for a while. You know what change is like there and what it's like trying to get things done in the General Assembly. What is the role of the legislature here? If the court does everything we want them to do, they say exactly what we want them to say, where does it go from there? What is the legislature and what does the governor have to do?
Right. So I had mentioned earlier that up until recently, there had been zero oversight and zero funding. And so at the end of 2023, the legislature had enacted the first ever in the state advisory committee that is responsible for looking at the status of Pennsylvania's indigent defense system. And along with that legislation, also put a small pot of money to grant to counties. And so that was, I had always considered as a first step, literally a foot in the door to a problem that had been like decades long. But so that really is where the legislature has to come in and say, we acknowledge this problem. We have begun to acknowledge it by saying that we need this committee to kind of tell us what's going on with our system, even though there's been lots of reports. But getting further into what actually makes a well-functioning system that has meaningful oversight to the various whether it be county level systems, other states have statewide systems. But so the legislature has to come in to put more teeth, more meaning into what it believes to be a better system, which means that attorneys have the resources that they need. They have the oversight to be the true professional body that they are and provide the representation that they want to. But also that ultimately means money. Like everything always comes down to money. Everything in the General Assembly has has a price tag, right? And they are always fairly, very aware of it. But so ultimately, right, it means more funding for public defense. Initially, they put $7.5 million, which roughly equates to about $100,000 per county. In some counties, that's not going to be enough to hire an attorney. Most counties haven't used that money for hiring attorneys, but have instead tried to use it for retention, bonuses, or perhaps some support staff. Um, but that's not nearly enough to tackle the problem. So not only is it going to require potentially some additional legislative action, but it's going to require the political will in order to see this as a value that it adds to communities, how it can actually keep communities safer by prohibiting people from being recycled into the criminal justice system. It will potentially save counties, lots of money in terms of its jail population because you have people who are able to have their cases resolved quicker. But so I think it's getting the legislature to see that there is still a larger problem and that there is more work to be done. Um, and looking at what potentially other states have done to make it more meaningful in terms of creating standards for attorneys to be able to follow. But additionally, again, those funds that have to be put there, because without the funds, it's an unfunded mandate. So you have to have the General Assembly put those funds there. And the governor, to his credit, has included indigent defense funding in his budget address this past year, and the year before that. He talked about it when he was campaigning. And so, largely expect that we would have to keep up this momentum, and hopefully have them do the right thing.
Can we just say some numbers here? I think you did say it was 7.5 million in the state budget, but I would just want to throw out some other numbers if I could. My understanding is as of a couple of years ago, the total spending across the state by the counties is approximately 125 million. And a comparable state, Michigan, which went through a very similar process, is spending north of $300 million. So there's a wide range here of what the state under Governor Shapiro has made available to counties. As you said, it comes out to about 100,000 per county, which is not much, compared to what the counties in Pennsylvania are spending for a system that the two of you have aptly described as not sufficient. And then you look at another state that's similar to Pennsylvania, where they're spending much more than that. So we're talking about a big ticket item here.
Absolutely. If we take the study that Ari had mentioned from Paul Heaton, that say in certain counties you need 10 additional attorneys just to get to the caseload national standard. That's not even like best practice. That's just barely enough attorneys to handle the caseload of those offices. Like, you talking about a county that needs it's it's $1 million itself.
Yeah.
And so, to kind of put that in context. And I think that is the education sometimes that legislators need, that, they see, a number like 7.5 million and think that's what could they possibly use all that money for. But when they have neglected the system for as long as it has, it's unfortunately going to take much more money up front in order to see positive results.
I think it's really important to note that, people listening to this, they may be donors to the ACLU, the ACLU of Pennsylvania, which of course supports our legal work. But there is, when we're talking about the legislature and the governor, that means there's an advocacy component here that people there, we need to build some political will. Now, of course, the court helps to grease those wheels a bit, in building the will, if they rule the way we want them to rule. But this is an issue for any of our allies, anybody listening to this who's interested in these issues. You can talk to your legislator anytime, pick up the phone, drop an email and say, hey, I just heard about this and this is outrageous. And, start to make that case for why legislators and the governor should get behind a more robust public defender system. Ari, I understand that this case could go on for a while. Can you tell us a little bit about next steps?
Yeah, there's been cases like this that have been brought in other states. You mentioned Michigan. Michigan went through this process a couple of decades ago, where litigation was brought, and that this state slowly, incrementally moved towards a system that was more adequately funded. So we recognize that this process might take a little bit of time. In terms of the litigation, we filed the lawsuit, and now the respondents, so the Commonwealth, the heads of the General Assembly, and the governor, have filed what are known as preliminary objections, which argue that the suit shouldn't have been brought, or elements of it should be dismissed. For example, they argue that we should just be suing the individual counties because it's Public Defender Act gives the counties the responsibility for indigent defense services. So it should just be their responsibility, and we should sue them. We're now going back and making arguments to the court about how the Sixth Amendment and other constitutional rights give this obligation to the overall obligation for indigent defense services to the Commonwealth itself. And so the Commonwealth has to play this broad oversight role of ensuring there's adequate funding and adequate supervision for indigent defense services. So we're currently working through those issues and briefing them to the court, and then we'll expect the court to make a ruling on those objections, and hopefully the case will then move forward with discovery and potentially a trial down the road.
Well, thank you both so much for taking the time. This is a potentially landmark case in Pennsylvania, so it's exciting. I know it's a ton of work. You've already done a ton of work, and there's plenty more to happen. So thanks for the time, and appreciate your insights.
Yeah, thanks. Happy to talk about it anytime.
That's Veronica Miller and Ari Shapell of ACLU PA. You can learn more about our lawsuit at aclupa.org/defenders. This is a great time to join the ACLU or to renew your support. Visit aclupa.org/join for more information. And that brings episode 91 to a close. The editor of Speaking Freely is Natalie Montero. Our opening theme is by Moody Finn, and our closing theme is by Elliot. Both are courtesy of bensound.com. The executive director of the ACLU of Pennsylvania is Mike Lee. I'm Andy Hoover. Until next time, be free.